Being a superhero, some people would call lawyers superheroes. I'm not one of them. No, no, I'm just kidding. BP lawyers are the real heroes in this world.
Let's jump into it. We got more ethics questions, guys. Thanks so much for joining. Here we go. Attorney McBeal represented a woman in an eviction proceeding in which the woman's primary objective was to retain residence in her home. The woman exhibited signs of mania many times during the representation. When Attorney McBeal sought to prepare the woman for a hearing, the woman appeared confused, unable to focus, and exhibited impulsive, disorganized thinking. Attorney McBeal reasonably believed that the woman lacked the capacity to make adequately considered decisions and that she was at risk of substantial harm with respect to her objective to retain residency in her home. Because Attorney McBeal believed that the woman's testimony at the hearing was crucial to retaining residency, Attorney McBeal urged the woman to seek counseling with a psychologist. The woman resisted because of her mania. Without the woman's consent, Attorney McBeal took necessary action to address the dire need to prepare the woman for court, contacting the woman's sister for help in convincing the woman to seek counseling. Is the attorney subject to discipline?
So the attorney realized that she was in mania and then just kind of did nothing and let trial proceed.
Well, the idea is, the question is like, is this client exhibiting signs of mania and the attorney reasonably believes that, like, hey, there's an impairment here and the impairment is material to the outcome is basically what the question is asking, right? So is the attorney subject to discipline for reaching out to a family member and potentially exposing client confidences?
Ooh, wow.
But in the client's best, arguably in the client's interest.
Wow. That's an interesting one.
Right?
I'm not super sure. What are my options?
Your answer options are A, yes, because the Attorney McBeal contacted the woman's sister without the woman's consent. B, yes, because Attorney McBeal sought to influence the woman's testimony in the hearing. C, no, because the attorney reasonably believed that the woman's diminished capacity put her at substantial risk of losing residency of her home. D, no, because the lawyer have implied authorization to disclose confidential information to third persons in the course of the representation.
Ooh, this is a rough one because you can definitely see it from both sides. It's like exposing personal information, but also it feels like there's so many times where it's like clear signs of mania. Yeah. So I think I'm gonna go with C.
You're gonna go with C?
She can go because it feels like the attorney has enough to act on.
Okay, that's correct.
Hey, let's go.
So this is a model rule 1.14 question. It permits a lawyer to take reasonably necessary measures to protect a client on behalf of a client when the lawyer reasonably believes that, one, the client has diminished capacity, and that, two, is at risk of substantial physical, financial, or other harm unless action is taken.
Yeah.
So it's a two-part test. Is that, one, they have to be impaired. You have to reasonably believe so.
Yeah.
And two, that has to have not materiality per se, but it has to matter. Right? Like, because of this, then this.
Yeah.
Right?
Yeah.
And the reason that matters is that if, like, let's say the client is manic and crazy or depressed or incapacitated, I don't know, in some way.
Yeah.
But it's unrelated to the matter at hand. You can't, as an attorney, just go to their friends and family and be like, hey, guys,
I think they're crazy.
Yeah. Exactly. Well, what's interesting here is that the fact that it was the client's sister is also material because comment 5 to the rule specifically says family members are among those that are appropriate to reach out to.
Yeah.
Right. And so this speaks to like the minimum force required test that's sort of throughout the entire rule set.
Yeah.
Is that like, hey, protective action includes consulting individuals or entities that can take action to protect the client, and such individuals and entities can include family members.
Yeah.
Right? So the closer the relation, the quote-unquote less risk there is to breaking confidences under 1.6. Right?
Okay.
And so that's why it was so important that it was a sister.
Yeah.
But you didn't know that, but I didn't teach you.
Hey, but I got through it, just based on intuition. I love when laws line up with intuition. You know what I mean?
Yeah. Well,
I think it's chill for you to talk to her sister.
To protect like the client, right? It's in the interest of the client. And the rules have a constant balancing act throughout them. That's their beauty. Boo walked into the office of Attorney Finch, a criminal defense attorney. Boo asked Attorney Finch whether he had heard that the police were seeking a man with a long scar on his right arm in connection with an armed robbery and nearby larceny attempt. When the attorney replied that he had read about the incident in the newspaper, the client rolled up his right sleeve to reveal a long scar on his right arm. Attorney Finch told him not to show the scar to anyone else.
Ooh.
A week later, the local prosecutor subpoenaed Attorney Finch to appear before the grand jury. The prosecutor told Attorney Finch that he knew Attorney Finch had met with a man rumored to have committed armed robbery, showing Attorney Finch a photograph of Boo, and asked if Attorney Finch knew whether Boo had a long scar on his right arm. Attorney Finch refused to answer the question.
Whoa.
Was Attorney Finch's refusal proper?
Wow. I don't know about the power of a subpoena.
I will say, I'll give you a hint here and say that, like, the method of the discovery is not germane to the question.
Okay,
The question is, like, regardless of the medium, is
Yeah.
it proper for the attorney to reveal
Yeah.
this information? So I'm going to throw you that one.
Okay, gotcha.
So, what are you feeling?
It feels like no. It feels like that's under attorney-client privilege. You know what I mean?
Yeah,
That's like on vibes. It's like, hey, like, do you have any damning evidence
on the
against
guy
your
we're looking for? Yeah.
against
Please.
the guy on a guy you represent? Like,
Well, here we go. Here's your answer options. A, yes, because Attorney Finch's observation was protected by the professional duty of confidentiality. B, yes, because Boo's act of rolling up his sleeve and revealing the scar was a confidential communication and therefore protected by attorney-client privilege. C, no, because Boo did not orally state that he had a long scar on his right arm. And D, no, because the crime-fraud exception to the attorney-client privilege applies.
ooh. I still definitely think this is well within the terms of attorney-client privilege of like,
Well, remember, never actually represented the guy.
oh, never represented the guy. Oh, huh.
Remember, Boo just walked into the office.
Yeah, but does Boo reasonably believe that Atticus Finch was representing him? Okay,
Remember, the entire interaction was he walked into the office,
Yeah.
showed the scar, and then they talked about whether that he had heard that the police were seeking a man for armed robbery, and then the attorney replied not to show the scar to anyone, and that was the end of their interaction.
Wow.
So is that enough?
I'm gonna go with D.
You're going with D?
I'm going with D.
D is incorrect.
Ah.
It was B.
Oh, it was B. That
Yes,
was the one I was gonna
because
go.
Boo's act of rolling up his sleeve and revealing the scar was confidential communication.
Yeah.
So this question is attorney-client privilege, as I hinted
yeah.
at. So the elements of privilege are stated in pretty stark terms. So any expression through which a privileged person undertakes to convey information to another privileged person, and for the purposes of receiving legal
Yeah.
advice. So basically, what happened is this triggers because he walked into the office
Yeah.
seeking essentially a legal consultation. Though we didn't use those words.
Yeah.
He showed a scar in the context of saying, hey, they're looking for a guy for a robbery. And then crucially, the attorney replied
Yeah.
saying, legal advice, don't show that to anyone. Even if the guy never goes on to hire that attorney,
Yeah.
attorney-client privilege extends to people in consultation. Because if it didn't, then the entire legal system would break because you'd have to share your secrets with an attorney, and then
Yeah.
when you didn't hire them, they'd just subpoena the attorney. and
Yeah,
then you'd tell-
exactly.
So you don't actually have to be a client to have attorney-client privilege. So what that means is that Boo's act of rolling up the sleeve, it was communication.
Wow. Hey,
Showing them
that
something.
feels just.
Yeah, it does.
That feels just.
And so it was absolutely proper that the attorney was like, I'm not telling you that.
Yeah, exactly. Nice. Okay.
Yeah.
Sweet. I got thrown off there, but
No,
nice. That's awesome.
I think like I threw you off at the beginning
Yeah.
because like this question has layers, but it seemed easier to you because you didn't know all of them.
Yeah, exactly.
So then I told you about the other
you
layers.
Introduced the other layers. So that, yeah.
But your instincts are
Nice.
absolutely correct.
You turned it into tiramisu.
Yeah, but the hard part of this question is that there's layers to this shit.
Yeah.
The hard part is that like is the attorney replying. Because if you had just shown, like, if on the bus you show an attorney something and the attorney says nothing in return and it's a public place and there's no expectation of privacy and the attorney doesn't tell you what to do about it, then you just that's not covered because there's no exchange, there's no understanding that it's confidential.
Yeah, but it was in his office.
It was in his office.
And it notes that it's in his office.
Yep, exactly. Yep.
Okay, yeah.
That was not storytelling.
Nice.
Yeah, but that's what. But a lot of people like get that wrong.
Yeah.
So that's a very
Yeah.
very very understandable misunderstanding.
I was on the right track till you threw me off. So credit to you.
I do love gaslighting. A recent law school graduate named Connor was hired by a law firm as a first-year associate to work in its trusts and estates practice group. Connor had taken the bar examination and was awaiting the results. A partner in the trust and estates practice group gave Connor general training in advising clients about the advantages and disadvantages of different approaches to estate planning and in drafting relevant legal documents. When the partner was unable to meet personally with clients, Connor did so. He took information from the clients and gave them advice based on the training he had received from the partner. Based on Connor's advice, the client made decisions as to how they wanted their estate handled. Connor drafted the necessary documents, which the partner reviewed before Connor gave them to the clients to execute. Was Connor's conduct proper?
This is an interesting one. It's, man, okay. So first-year associate gets what?
First-year associate who has not been admitted to the bar.
Oh, but the clients are clients of the law firm.
Yeah, presumably.
Oh, I'm gonna go with the legal boss. That sounds bad.
Well,
whatever answer option is bad, I'm gonna
here's-
go with that.
Here's your answer options. A, no, because he gave legal advice before being admitted to the practice of law. B, no, because he drafted legal documents before being admitted to the practice of law. C, yes, because he was acting under the general supervision of the partner. And D, yes, because the partner reviewed all documents drafted by Connor before they were executed by the clients.
Oh, well, if the attorney supervised all of them, it feels like that's. I think I'm gonna go with D because it feels like if the attorney had looked over everything, then that's good to go. So I'm gonna go with D.
You're going with D?
Yeah.
Well, that's incorrect.
Oh.
Because the question specifically said Connor drafted the necessary documents. The question that would be true.
I thought the D introduced a new reality, and I thought that reality was
took
true.
it hook, line, and sinker, but it was not. That was the whole point. That was the call of that question. So the correct answer is A. No, Connor's conduct was not proper because he gave legal advice to clients before being admitted to the practice of law. Personally meeting with clients and giving them legal advice constitutes the practice of law, regardless if it's technically under the supervision or under the training of an admitted attorney. Because if that wasn't the unauthorized practice of law, then what an attorney could do is have one attorney and then just train an office full of non-attorneys what to do, and then they just practice law. You know, it would be loopholes so big that it would make licensure meaningless.
Yeah, exactly.
So law graduates are not authorized to practice law until they have been formally admitted to the practice of the jurisdiction, even if they've taken the test and passed the MPRE and graduated from a law school and done all that stuff. Even if they've done all of that, not good enough.
Yeah.
That they're still waiting for their admission. And general supervision is not like sufficient to avoid that issue.
Okay. Yeah, that makes sense.
Yeah.
Wow.
So clients and legal advice is generally speaking taking the law draws a distinction between legal advice and legal information. So like legal advice is applying a set of facts to the law. Legal information is just telling you about the law or the systems of the courts or whatever, right?
Yeah.
The moment you ask, but what should I do? That's when it becomes, that's usually the bright line that it becomes UPL.
Yeah.
So like a non-attorney, like we do this, we make ads where like it's just me like talking about like family law.
Yeah, exactly.
And that's completely fine, even though I'm not practicing.
Yeah, exactly.
Because I'm not saying here's what you should do. I'm just saying like, hey, here's how child support works.
Yeah,
in Washington,
exactly.
Right, and like informational stuff. You can have a website that tells you about the law.
Yeah.
It's when what you should do, client. That's
when you're telling someone.
When you're
what
telling
they
someone
should do.
specifically. Yeah, exactly. And the bar tries really hard not to like come down on people. For like trying to do the right thing and then tell clients. Yeah. Usually it becomes they take a much dimmer view of it when it's for money. So like if you're charging people and advising them what to do, like you'll get less, generally speaking, you'll get a lot less wiggle room.
Yeah.
And if you're just like, hey, yeah, okay, like you maybe like I've read lots of in my professional responsibility class, we read cases that were like, okay, this bumbling oaf broke some rules with UPL, but he was he didn't charge them anything. He was genuinely just, and so they usually like reprimand him, hit him with some fines and then let him go. Like, don't do this again, right? But they come down pretty hard on people when it's like when they're like charging people and misrepresenting their status as an
Yeah.
attorney, when it's much more deliberate.
Fraud.
Yeah,
Yeah,
exactly. They don't like that at
Yeah.
all. This is, by the way, this is
American Bar Association, not a fan of fraud.
yeah, exactly.
Yeah,
Well, to be clear, this should not be construed as an encouragement to bumblishly, oafly commit unauthorized practice of law. Don't do that. It's very perilous.
If you do it in a goofy way, in a goofy enough way, if you commit fraud and you're so
And you're
bad
just
about
kind
it
of-
that people think that it's accidental,
well,
that's
funnily enough,
the
that is-
Sam Bankman-Fried defense.
that is
Yeah.
actually like a defense to criminal liability. Is that like if there's an intent requirement, there are
Yeah.
some circumstances where your conduct is so stupid and egregious that you could argue, well, he really thought it.
Yeah, exactly.
And depending on what you're being charged with, that can have a material impact on whether or not the charges stick. Usually, to avoid that shit, they just slightly lower the charges, so there's
Yeah.
no specific intent requirement. But I digress. An attorney, Matt Murdock, worked as a superhero for the last 8 years immediately prior to reopening his law office in New York.
A superhero.
Murdoch printed and mailed an announcement of his return to private practice to members of the bar, previous clients, and friends whom he had never represented. The printed announcement stated that attorney Murdoch had reopened his law office, gave his postal and email address and telephone number, and added that he had served as a superhero for the past 8 years. Is attorney Murdoch subject to discipline for the announcement?
I don't think so. Especially if you're a superhero, one's got to assume you've got
He's
some.
just a really good attorney.
How did you just do that? I'm a really good lawyer.
You can send out a mailer letting people know where your place of business is. I feel
think
like that's more than reasonable.
That's pretty safe. So here are your answer options. A, yes, because the mailing included persons who had not been his clients. B, yes, because his service as a superhero was unrelated to his ability as a lawyer. C, no, because all the information was already in the public domain. And D, no, because the information in the announcement was true.
Ooh. I think it's, being a superhero, some people would call lawyers superheroes. I'm not one of them. No. No, I'm just kidding. Sorry.
The real heroes here are the lawyers who charge $800 an hour.
Yeah, exactly. The real hero is a big law associate representing BP. Lawyers, BP lawyers are the real heroes in this world. I think I'm gonna go with B because I don't think it's a B for BP. I don't think
Who will think of the shareholders?
Yeah, I don't think your time as a superhero has any effect on your life as a lawyer, and so sharing that information doesn't feel relevant. And you're smiling, which means you get to tell me that I'm wrong.
That is sadly wrong. The answer is D. No, because the information in the announcement was true. So attorney advertising faces some constraints, but this specific question speaks to the general constraints on attorney advertising, which is modeled under Model Rule 7.1, which covers lawyer advertising generally and prohibits only 1, false or misleading communications, and this communication was neither false nor misleading.
Yeah.
Right. So what you can't do, your prior work history can be relevant. Like I have a buddy of mine in law school is a resident. Like he's a doctor. He's an MD, and he's also in part-time law school.
Yeah.
And so, sure, being a doctor may not directly be relevant to your ability to practice law, but if you do med mal and you're and your lawyer is also a doctor, that's going to be pretty relevant. That's going to have impacts on whether or not clients want to hire you. It's going to have impacts on your expertise. And Matt Murdock worked as the Daredevil.
Yeah, exactly.
And some people are going to like that,
I
right?
know.
And so the power, the model rules protect clients and the public. They don't constrain attorneys when the impact would be detrimental to the client's ability to choose the practitioner. So if he couldn't talk about his work as the Daredevil, that's material information that that a client might want to know when picking an attorney, right? So the constraint is only it's got to be true. And then after, as long as it's, generally speaking, as long as it's not true, untrue or misleading, then the client can decide. And so the model rules say that's enough.
Nice.
Now this we've talked about it before. There is a prohibition on solicitation.
Yeah. Right.
But that's because beyond a certain point, the interest of a client picking begins to diminish when you have all these injury attorneys knocking down your door trying to so there are limits. But
Well, I'm picturing a world where injury attorneys can just wait outside hospitals and
that's what they
like
would
send
do.
private limo services. Like, oh my god, devastating
terrible.
to hear about the chemical fire.
Look what they did to my boy.
God,
yeah, exactly. Well, I mean, you laugh, but because the rules constrain the lowest common denominator, you'd have firms that would do that.
Yeah.
They would sit
100%.
outside of funeral homes,
Yeah.
they'd sit outside of hospitals, they'd sit outside of rehab centers, they'd sit outside of every place of tragedy.
Yeah.
And try and prey on emotionally vulnerable people.
Yeah.
And we had to make these rules because they did that.
Yeah, exactly. Yeah,
they-
obviously they
did
would.
that.
Yeah.
And because it only takes one. And then once you have one law firm doing that,
Yeah.
it becomes a prisoner's dilemma race to the bottom.
Yeah.
Where kind of like how firms are like recruiting earlier and earlier and
Yeah,
earlier.
yeah.
They're doing that because one guy started recruiting earlier.
Yeah.
And then everyone else had to start moving up their timelines. And now big law firms, just this week I heard, are asking people to apply as they hit law school.
Whoa.
Like the first month. They're like, apply now. They're basically applying on their law school admission stats.
Yeah.
Their
Wow.
LSAT and undergrad GPA.
Wow.
And not their law school GPA.
Pretty soon they're gonna start working like soccer teams in like Europe where they're like recruiting 16-year-olds like
and
for
babies.
Uh-huh,
yeah, exactly. We're headed in that direction.
Yeah.
Attorney Gambini wrote a letter to the editor of an online newspaper. In the letter, Attorney Gambini provided a detailed account of serious side effects that he had experienced after using a drug manufactured by a pharmaceutical company. In addition to describing the side effects, Attorney Gambini sharply criticized the company as being greedy, careless, and indifferent to the harm that it was inflicting on the public through its various drugs. He urged other sufferers to publicly disclose their experience to, quote, stop this reckless drug company. A woman read Attorney Gambini's letter and, after a brief correspondence, retained him to bring a products liability action on her behalf against the pharmaceutical company. Soon after the attorney filed the complaint in the action, the pharmaceutical company learned of Attorney Gambini's letter to the editor and demanded that he retract it immediately. The attorney refused, and the company filed a grievance against him with the state bar. Is Attorney Gambini subject to discipline?
Whoa. Man, this question is not sponsored by the Sackler family. I'll tell you what. Of all the people in the world, the Sackler family hates to see this question coming.
Yeah.
Shoot. So did the lawyer represent the family at any point?
Well, see, that's the thing. So here in the fact pattern, this was a statement made before this lawsuit started.
Yeah.
It was before the lawsuit started.
Oh.
So it was a letter to the editor of an online newspaper, right? And the attorney talked about the side effects generally of this drug, and then someone saw it and retained them, right?
Wow.
And then he filed the lawsuit. So Kent is talking about this thing publicly improper.
Shoot. I don't think so. It feels like it's like, I don't know. You should be able to talk about bad drugs.
Yeah, I think so. So here are your answer options. A, yes, because Attorney Gambini made an extrajudicial statement by way of public communication that he knew would have a substantial likelihood of materially prejudicing an adjudicative proceeding involving the company. B, yes, because Attorney Gambini solicited clients by way of an electronic communication.
Ooh.
C, no, because Attorney Gambini's letter to the editor was written before he became involved in the litigation against the pharmaceutical company.
Yeah.
And D, no, because Attorney Gambini's letter to the editor amounted to a warning of danger concerning behavior of the company, which he had reason to believe threatened substantial harm to the public.
Yeah. I think like D is also kind of correct, but I think C is more correct because it's just like it was before he was involved. He can't be held. It can't be held against
You don't know
him.
the future.
Yeah, exactly.
Right? You don't know the future, and also remember, attorneys do have First Amendment rights.
Yeah.
Which is actually, fun fact, why attorneys did not used to be able to advertise.
Oh,
at all.
Oh, whoa.
But what blew it wide open is that some attorneys went to the Supreme Court and they said, "Hey, we have free speech rights.
Yeah.
You have to let us advertise
Wow.
that commercial speech is speech, the subject to certain limitations.
Yeah.
and that's why you have lawyer TV ads now.
Wow.
And that's actually also how Morgan & Morgan got big, because Mr. Morgan got out of law school, was only like a couple years out of law school when that prohibition dropped. And he was one of the attorneys who was like, whoa, this advertising thing is huge.
Yeah.
And he was on the first wave, and then he got big.
That's crazy.
Right.
Wow.
So he was an early adopter.
Yeah.
But I mean, everyone else has been scrambling to catch up ever since. But that's what allows attorneys to advertise.
Wow. And the domino at that end, and then domino to corporations being people.
Yeah.
At the
Yep.
other.
And then Reagan somewhere in the center.
Yeah. Big domino in the middle. Yeah, I think I'm going to go with C. I'm
You're
locking
with
that
C?
in.
You're absolutely correct.
Hey, let's
You're
go.
absolutely correct. C is correct. No, because Attorney Gambini's letter to the editor was written before he became involved in the litigation. So there is actually layers to this question that you did not know about.
Oh.
Model Rule 3.6 does restrict extrajudicial discussions to from a lawyer who is participating in who used to participate in an investigation or litigation.
Yeah.
So you can't like go to the newspaper after you filed stuff and start just saying whatever you want. Now you can talk to on behalf of your client to the press.
Yeah.
But the idea is the model rules don't want attorneys going to the press and like just trash talking each other outside of court, right? And so there are some limitations.
Like MMA press conferences.
Yeah, doing a face-off with opposing counsel. Yeah, so there are limits under Model Rule 3.6, right? But in this case, Attorney Gambini had already written the letter before the litigation, and there was no investigation at the time. He was just like, hey, guys, this is something big. He has, within certain limitations, he has First Amendment rights.
Yeah.
And the client saw him and retained him after. And so the pharmaceutical company, at least on this basis, can't have him take it down because, like, hey, man, like, he didn't know she was going to hire him because of that. You know, we have nothing in that fact pattern.
Yeah.
So if you can be retroactively held accountable for everything you've ever said, just because sometime in the future you take a case, that would mean attorneys can never say anything.
Yeah.
Anywhere.
Which they have to
But
be
they
able
have to be
talk.
able to. Yeah, exactly. So
that's their job.
yeah, that's kind of their job, right? Exactly. So it's an interesting balancing act. Yeah. But you'll see, that's why you'll see a lot of attorneys make you can talk to the press, but you have to make very non-specific statements. It depends on the state's ethical rules, of course, but like you'll always see in high-profile murder cases, like, he didn't do it, and the evidence will show he didn't do it.
Yeah.
And that's usually more or less all they say. Like, how's your client feeling?
Yeah.
You know, they never go into the details of the case because, especially in matters of high publicity,
Right.
they don't want to be like, Luigi Mangioni's bag was searched because Officer Gambino started searching it without, reading him didn't get a warrant or whatever. They don't talk about that stuff because they know potential jurors in the jury pool are watching. And so if it's imminently before an adjudicative final proceeding, you can't like go to CNN and be like, ideally, the Trump administration does this all the time, so I don't know who's stopping them. But it's bad form to like trash talk extrajudicially because it's like the court of public opinion. Lawyers are supposed to be above the fray. But personally, I've never really seen 3.6 or any of its state equivalents enforced very often. But
wow,
your mileage may vary. If there's ethics attorneys in the audience, please tell me. But I've never seen anyone hauled out for this one. Attorney Giardi agreed to represent a client who has been seriously injured in an in-flight accident. Before filing a lawsuit, Attorney Giardi entered settlement negotiations on behalf of the client with the insurance company for the party responsible for causing the accident. Attorney Giardi provided the client's medical records and related expenses to the insurance company, as well as the report of treating physicians who opined that the client would continue to incur substantial medical expenses in the future. Attorney Giardi reached an agreement in principle with the insurance company, which was approved by the client, but before the settlement agreement was finalized, the client unexpectedly died.
Whoa.
Attorney Giardi signed the settlement agreement on behalf of the client without informing the insurance company of the client's death.
Whoa.
Is the attorney subject to discipline?
Does it say whether the attorney was like given attorney? Well, I guess they've got attorney privileges.
Attorney-client privilege does survive.
Yeah. Oh,
the death of the client.
Yeah.
So is his death? So I'll give you a hint here. There's two competing interests.
Yeah.
Candor before the tribunal, which is before a tribunal, but there's also a duty of general honesty.
Yeah.
So it's not just before the tribunal. So that's the wrong word. But like there's candor, duty of candor in all things.
Yeah.
And confidentiality and client authority. So which one of the three interests wins out? Because all three at least have a little bit to play here.
Dang. Okay. Yeah. What are my answer options?
Okay, your answer options are A, yes, because Attorney Giardi failed to inform the insurance company of the client's death. B, yes, because Attorney Giardi provided the client's medical records to the insurance company. C, no, because the insurance company could have learned of the client's death through due diligence. And D, no, because the fact of the client's death was information relating to the representation. So is the attorney subject to discipline?
Yeah. I think it's got to be D, because it's. I'm gonna just. I guess I'm believing that attorney-client privilege. He's just like, well, he told me to sign these, and so I'm just following through his wishes. I'm his attorney. Boopity boopity boo.
And off you go. Bing
yeah,
bang
off
bong,
you go.
$1 million check.
D.
Well, that is incorrect. The correct answer is A. Yes, he is subject to discipline because Attorney Giardi failed to inform the insurance company of the client's death. So what wins out here is candor, because there is a materiality test in all candor, and something that is material to this negotiation is the client's death.
Yeah.
Because the insurance company negotiated a settlement on the presupposition that he would continue to incur medical expenses into the future.
Yeah.
So the settlement was higher because of that.
Yeah.
Question for you: do dead people have medical expenses?
No, not really.
And so, and remember, the attorney gets more money if the insurance company doesn't know that. And so when he lie by omission is still a lie.
Yeah.
If attorneys are not obligated to affirmatively disclose material facts, like if you could have discovered it through due diligence, that could mean almost anything. I could discover almost anything through anything. Right?
Yeah,
and so
yeah.
if that's the standard, it would basically just encourage attorneys to just lie.
Just lie. Yeah.
Lie by omission, because to take advantage of the asymmetry of information in their possession.
Yeah.
Right. And so here, by purporting to settle the matter on the client's behalf, which he didn't because the client was dead.
Yeah.
After learning of the client's death without disclosing the death to the insurance company, he misrepresented a highly material fact in violation of model rule. This is under 4.1, because he no longer had a client.
Yeah, exactly.
He in theory, he didn't even represent the estate. The estate's representative has to be appointed.
Yeah.
But assuming even then, he would have to be rehired by the estate in certain circumstances. We don't have enough information here. But like misrepresentation can occur by misleading omission that are the equivalent of affirmative false statements. And that is under ABA Formal Opinion 95-397. So those are binding opinions. So there's like a subset of like advisory opinions that the ABA and other bar will publish their interpretations of the rule. And if omissions were not damning, that would break the whole system.
Yeah. Wow. That's cool.
The settlement agreement, like the question tried to trick you a little bit by making you think that the client had an authorized settlement, but it said client authorized settlement.
Yeah, I felt like I was way out of my depth as soon as it was like authorized settlement, and so it's like, okay, can a dead person vote if their attorney?
Yes. Yeah, well, I mean, it's because there's an interesting question there, because the allocation of authority between client and attorney is actually like a subject of itself. So, like for example, the best way I describe it is that like the attorney is the Uber driver, the client is the passenger. The client picks where they're going and arguably how fast they get there, but certainly where they're going, and they decide when the ride stops.
Yeah.
Right. The attorney's authority is how to get there. They decide what roads to take. They decide when to brake. They decide when to turn right or left.
Yeah.
But when the ride is stopping is never their authority. They, in a civil suit, in a civil setting, they can never settle on behalf of their client. And they can also never disclose client information unless it's implied in inherent in the situation to provide legal representation. So, for example, an insurance plaintiff, like suing an insurance company, has generally speaking, implicit authorization to hand over medical records.
Yeah,
because you got to prove your damages. That's inherent in the whole thing. And so, if attorneys have a little bit of leeway for like clearly implicated authority to disclose, under limited circumstances, because if they didn't, they'd have to be like, "Hey, client, can I give them your physical therapy records? Can I give them your?" But like,
they have to have some ability to act.
Yeah, to act without every minor thing. But one of the absolute bright red rules is that you can never settle on behalf of your client. So that's why the language. Like authorize the settlement was so critical there.
Yeah. Ah, okay.
Yeah. Because cool. It's a little bit different in, like, for example, in criminal cases, you can also settlement is still in the client's authority, but it's a little wider. Like criminal settings, there's no such thing as a frivolous argument.
Mm-hmm. Gotcha.
There's no such thing as a frivolous argument because the constitutional. But there is a such thing as a frivolous argument in a civil setting.
Oh.
Right. And so you can, in a criminal setting, the attorney is assured they will never be subject to discipline for making the government prove every element of the crime, no matter how ridiculous it is.
Nice.
So they caught you on video in 4K
Mm-hmm.
saying, I committed the crime.
Yeah.
I have the mens rea and the actus reus for this.
Yeah.
You say it to the camera, and the attorney can look at that footage and say it's fake.
Yeah, exactly.
It's all, they could be
we
like,
have to test his shoe size.
yeah,
first.
like we didn't, and so it can appear a little silly, but the safeguard there is that what they don't want is if the government goes rogue.
Yeah.
They don't want the government being able to pressure the attorney's license as a way to get them to stop pursuing the case.
Yeah.
So they baked it into the rules in every state that I know of. There is no such thing as a frivolous argument in a criminal setting.
Nice.
So your license is safe if you do, and it really frees the attorney's hands to make the government prove every point.
Yeah.
which helps you. It may seem a little silly if you ever watch a criminal defense attorney defend someone you hate, and the attorney's like, this attorney's making ridiculous, frivolous arguments.
Yeah.
That's they're protecting you by making sure the government has to meet its burden every time.
100%. Well, it's like it's so sensationalized by like especially news media.
Oh, yeah.
Is like you'll hear about, oh yeah, and then the attorney tried to make this case, and it was like, well, he was grasping at straws, which you want your attorney
to be able to grasp at straws. Yeah, but you're going to jail. Like, for example, in a DWI or DUI, depending on what your state calls them. I think we call them DWI here. I'm not a DWI guy myself. Neither a practitioner nor a preventer.
Don't love doing it.
Yeah, you guys laughed a little too hard at that. I got a buddy who does those, and he's like, yeah, if they've got the money, here's what I'm going to do. I'm going to call the officer in. I'm going to question every piece of training he's ever had. Then I'm going to ask for the breathalyzer machine that they had him blow into, and then we're going to talk. And then we're going to go to the crime lab that process and calibrates them. And I'm going to get the tech, and I'm going to talk about every training he's ever had, and I'm going to look over every case they've ever done, and like, what's your error rate? Or is there a false positive here?
Yeah.
Were the machines, was there a recall ever issued by the they can go to the manufacturer and talk about, but the problem is that most people don't have the money to do that. But if they do, your attorney can raise every possible issue,
which is why Tiger Woods is still on the road.
Yeah, that's actually why. Yeah. Right, and that's one of the reasons why and what's even more interesting is that you can't charge a contingency fee in criminal cases.
Yeah.
It's like you can't you don't pay me unless I win isn't a thing in criminal law.
Yeah.
And so what that means is that it's way more expensive to get a criminal law attorney because the attorney's got to charge you up front. And so what that means is that only rich people get all the justice.
Yeah.
Right? And how do I feel about that? Like, are we literally not allowed to do that? On one hand, what they want is they don't want attorneys being encouraged to cheat. Getting people, encouraging people. I don't know, encouraging people to commit crime, and then they get an attorney for free, and then the attorney gets them off, so they get paid. There's some predatory concerns there. I'm personally never convinced that the hypothetical disadvantage of a system like that would be worse than the actual concrete reality of not being able to have an attorney.
There might be some misuse, but there might be more justice.
There might be more justice, right? And so the idea behind that policy is that we've got public defenders.
Yeah.
That's the idea, is that they'll hide behind everyone's got an attorney in the criminal system. Yeah, but the problem is here in Washington, your criminal defense, your public defenders, to be very clear, public defenders are not bad attorneys. I want to be very clear. There's public defender slander. Those guys work incredibly hard 24/7. They're
100%.
Not incompetent attorneys. They're in trial often more than private attorneys. But the problem is that here in Washington, each one of them has got 300 cases.
Yeah.
Right? So they're not bad attorneys. They just don't have enough time to spend on your case by not by their choice, but by the fact that the state has given them so much work it cannot possibly be done.
Yeah.
And so the state, I think I've talked about this once or twice before, is the other year was just okay, we're just capping the number of cases a PD can have, right? Which may sound great, but they capped the number of cases a PD can have and then did not expand the number of PDs and did not provide any resources to actually, they just stopped them working. So what this means is people sit in jail waiting for a PD. And so the PDs were super fucking pissed about this because they're like,
Yeah.
this isn't solving the problem.
Yeah, exactly.
Now you're just, before it was bad, but now we're also just warehousing people. And of course, everyone charged is poor.
Yeah, exactly.
So like if you spend just an extra week in jail, that could be the difference between your job.
100%.
If you don't have a job, you can't pay for,
Well, and there's so
life.
many cases of like people who were locked up
for years.
for years and weren't even guilty. Well, there was like, I don't know. There's been just cases of younger. I don't want to quote anything from cases in case I get it wrong, but
We've all heard of them.
kids dying in
Yeah.
jail on bung offenses.
They found like an ounce of marijuana.
Yeah,
And it wasn't even his bag.
Yeah, it wasn't even. Yeah, exactly.
or stuff
Not
like
even
that.
tied to him, and then this kid dies.
Did I tell you that in Washington until a couple years ago, they did not have to prove knowledge in drug charges? Yeah, they didn't have to prove. All that the state had to prove in Washington state for, I think, felony possession, for drug possession, I forget what the exact charges were, was that you had drugs and they were on you. If it was someone else's bag, someone else's pants, you didn't know they were in your pocket, you didn't know they were even drugs, but they were drugs, state did not have to prove that you knew. Right?
That's horrifying.
And the reason I bring this up is that the Supreme Court actually threw that out. They're like, no, like, because what happened is I think what happened is like some lady thrifted some pants or a bag or had a bag on her and it had like a small amount of drugs, and then state was like felony. And she's like, I didn't even know I had the drugs on me. And so they what they had done is they had bypassed the mens rea intent, like knowledge element of the crime, and they just had to focus on actus reus, which is usually the easier part to prove.
Yeah, exactly.
Is that you did it. The specific intent for serious charges is usually the hard part.
Wow.
On average. And so that has been corrected, and the Supreme Court said, legislator, you got to rewrite. We're throwing these out, and so many people got their convictions overturned. Legislator, we are throwing this out. Give us new intent. Give us an intent requirement in the criminal statutes, and so we had to rewrite them.
Nice,
but that is a horrifying reality.
Yeah, exactly.
Because state government does not have to prove you even knew you had cocaine on you.
That's crazy.
Like in the trunk of your car.
Yeah, exactly.
Like your buddy borrows your car.
Yep.
He gives it back to you. You go on your weekend trip to to the Hamptons or whatever.
Yeah, exactly.
They pull you over on the way. They find an 8-ball in the back. Felony. You're going to jail. See you in 5 years. Right?
It's crazy.
Right? Exactly. I'd be so fucking pissed.
I know.
Because the it wasn't me isn't necessary. Like there's like, well, we had it on you.
Yeah.
Officer, did you see the drugs? Yes.
Yeah.
Was the suspect within, armed? Was it his car? Yes.
Yeah.
Boom.
Uh-huh.
They don't even need to worry. Like, didn't know about it. Doesn't matter.
Yeah.
PD, like the pipeline for most attorneys is you do your time. If you want to do it in criminal law, you do your time in the PD, right? PD is always hiring. You can get a job for like $80K there.
80K,
fine,
yeah.
insurance. It's a job.
Yeah.
80, and I think they like max out at like 150 if you do 20 years.
Yeah.
Which is like not bad, right? But like it's public service, right?
Yeah.
And so like the pipeline is you get so much fucking courtroom experience that you work as a PD for 2 to 4 years.
Yeah.
Go into private practice. Now you know the prosecutors, you know how the machine's made, and you can negotiate with state's prosecutor a lot easier.
Yep.
Like a lot of attorneys I know charge flat fee, so they're like, hey, I'll handle your felony up to XYZ for $10,000. And then if the business is that if you can then call up the prosecutor and be like, hey, drop it, community service. And they say yes, you just made $10,000 for one phone call.
Yeah.
That's the idea. Right. And then so what they'll do is then they'll gate representation. They'll be like, hey, through negotiation, I'm making stuff up, but you could structure it all sorts of ways, like through negotiation, this much money to take your case. I need this retainer. If we get to trial, it's this much is owed before trial.
Yeah.
If we do an appeal, it's another 100. But and like for example, the high ticket guys who represent like Jay-Z and shit, those guys will be like $250,000 up front. Right. I need it right now.
100%.
And I personally respect the hell out of the criminal defense guys. I could not be in that business. We just work hourly here.
You got to be so easy with conflict, man.
Well, I mean, it's interesting because family law is good people on their worst behavior.
Yeah.
And criminal law is bad people on their best behavior.
Yeah.
And so which one is
better? Which one is better?
Honestly, I sometimes think that the criminal law clients would be better behaved. They'd be scared.
Yeah.
Right. But everyone, I don't know about everyone listening to this, but like I've had times in my life where I was a monster and I said things I wasn't proud of. Like we're human. Like we have those moments of brief insanity where we just do or say things we regret later.
Yeah.
Right. And would I want to be around me when in the distant past?
Even worse. Yeah.
I was like that? No.
Yeah.
No. But
Yeah.
I know bad people who shape up for
Yeah.
a period of time, and they're far more tolerable to be around.
Yeah.
For several years, Attorney Matlock, a transactional partner in a law firm, had represented a large grocery store chain in its ongoing business transactions. Recently, the grocery store chain's president learned that a litigator in the firm had been advising a major manufacturer about the possibility of suing the grocery store chain. Concerned that the litigator might have access to the grocery store chain's confidential information, the president asked the firm to stop representing the manufacturer in connection with the potential lawsuit because of the conflict of interest. The firm refused, but offered to screen the litigator to prevent access or misuse of the grocery store chain's confidential information. The grocery store chain's president declined the offer. On behalf of the grocery store chain, he retained an independent lawyer and sought an injunction in a civil action to bar the law firm from continuing to represent the manufacturer in connection with the potential lawsuit. Is the court likely to issue the injunction?
Oof, this is a rough one, especially when I don't know what an injunction is.
It just means in order to stop doing something.
Okay, cool.
In order to restrain.
Yeah. Okay, cool. Injunction function.
Is the court likely to stop the law firm?
Yeah. Okay. Is the court likely to stop the law firm? Okay. Yeah. No, this makes sense.
Here's your answer options. A, yes, because the law firm's violation of the conflict of interest rule gives rise to civil liability per se. B, yes, because the law firm is breaching its fiduciary duty to the grocery store chain. C, no, because the law firm is not committing an act of professional negligence. And D, no, because the proper remedy is a disciplinary action, not a civil suit.
Ooh. I think I'm going to go with A because it sounded very fancy. It said per se. It said and what was the rest of that answer?
It just drives to civil liability per se.
Yeah, civil liability per se. I'm going to go with A. I think that might be my worst guess of the day. Okay, wait. I feel like you should condescend to me and like try and get me on the right path.
So here's the hint I'll give you.
Yeah.
Is that an attorney or a firm, depending on the imputation status, an attorney generally cannot represent two parties when their interests are directly adverse in the matter of representation, or their involvement is likely to materially limit their advisory to one or the other. That's the two-part test.
Yeah.
So they don't even have to be directly adverse to each other. Here, potential lawsuit against each other and the long-term grocery store chain. Right? And so which one wins out, right?
Okay. Gotcha. So is it definitely like C or D? Like
no.
Okay.
I'm gonna hint. This is a multi-layered one. So I'm gonna eliminate C and D for you.
Eliminate C and D. That means it's B, right? Wait, or did I get it right originally and it was A? Oh man. Because now we're getting down to I had the reasoning right, but it's okay. So it's but what was B? Read
B. Yes, because the law firm is breaching its fiduciary duty to the grocery store chain.
Okay. Yeah, I think
you're locking in B.
B. Yes,
that's correct.
Oh, okay.
Yeah,
cool.
B is correct. So there's a multi-step. There's a multi-step issue to address here.
Yeah.
So what's going on is that you can't represent clients adverse to each other here. Direct parties in a lawsuit.
Yeah. So
you without the written consent of both parties. So you can ask the clients and be like, "Hey, there might be a material limitation.
Yeah.
Here are the disadvantages and potential risks to you. Do you consent?" But here, grocery store said no. So that means they can't represent them both.
Yeah.
And the grocery store chain was the first, so generally speaking, you wouldn't invite that issue.
Yeah.
Now there is a little bit of wiggle room where, like, if if attorney worked at a different firm and then moved to a firm with a client adverse to an old client that they're no longer working with, and then you can screen them off as a matter of right and notify the old client that like, hey, they've been screened out.
Yeah.
That's under Rule 1.7, may also establish a breach of fiduciary duty by the law firm. Quote, a lawyer must avoid impermissible conflict of interest, and a lawyer is civilly liable to a client if the lawyer breaches a fiduciary duty to the client set forth in Section 16.3. So you can have civil liability and ethical liability at the same time. They're independent. I personally don't know any situation where if there has been a breach of the rules, there wouldn't be at least some sort of arguable civil action in parallel.
Yeah.
I'm no ethics, like I'm not an ethics attorney, but like I've never seen a red herring where it's like, well, the real remedy is a lawsuit or a real remedy is disciplinary action. Because the jurisdiction of the bar begins and ends at an attorney's license, not compensation. So like that's what the civil system does.
Gotcha.
So what bars will sometimes do is they'll order like restitution, but it's usually very limited. So then you'd like sue the attorney in parallel. We see this with like quote unquote the miracle attorney. There's an immigration attorney, or was an immigration attorney in Tukwila, and the other and the other month she is facing a lot of bar complaints. And I think she resigned in lieu of discipline. She is also facing a massive federal lawsuit.
Yeah. Okay, so both at the same time.
Yeah, exactly.
Gotcha. Wow. That's crazy.
Yeah, it's again, ethics is a whole beast of its own.
Yeah.
But guys, thank you so much for joining us on this episode of Further Study. Hit the bell, send this to a friend, send this to an enemy, and we will see you again very soon. Thanks so much.
Yeah.